does place some rather stringent requirements, I think, upon an insurance company, but it may not be the total panacea to immediate financial success in business for all plaintiffs' attorneys. Read the case first.
Obviously, you must read the case, but you notice the tremble in defense counsel's voice as he mentioned that. Now, statutory costs are governed by CCP 1141.21. Party requesting a trial de novo who does not improve on the arbitration award does not recover costs, and the other party is awarded all costs, including but not limited to those specified in sections 1032.5 and on, which basically are jury expenses, costs for execution of judgment to judgment creditor, costs of taking necessary depositions to prevailing party, and costs of service of summons and subpoenas. Now, in regard to expert witness fees, the party requesting the trial de novo who does not improve on the arbitration award pays to the other party the reasonable costs of the expert witnesses. Now, such costs and fees, other than the compensation of the arbitrator, shall include only those incurred from the time of election of the trial de novo. Now, there are certain exceptions from these sanctions. Now, costs and fees that are otherwise chargeable to an unsuccessful party for a trial de novo are not imposed if the court finds in writing and upon motion that imposition of these costs and fees would create such a substantial economic hardship as not to be in the interest of justice. This, of course, is of great benefit to plaintiffs in personal injury cases. I would doubt, Bill, that they would assist many defendants.
Well, the great majority of defendants probably do have some sort of insurance coverage, but in the committee hearings there was concern about both plaintiffs and defendants who would be in forma pauperis. You've mentioned about the costs and the type of sanctions that are involved. I think probably this is a good point to mention again, Norm, something that you raised earlier about when to file the cost bill with reference to the arbitration itself.
Yes, Bill, that's a good point. I mentioned earlier that I would suggest that cost bill be added to your plaintiff's summary. That way, in the event that the arbitrator doesn't give you the cost because he forgets, this is going to be a way to remind him that they're there. I think it's very easy to forget these things, and it means that if you let the time period elapse, I think it's 10 days, then you as a plaintiff or defendant, you're going to have to go to court, make an extra appearance, and get these costs awarded. So add them to your material that you submit to the arbitrator. Now, you touched on the forma pauperis situation, Bill. If an unsuccessful applicant for trial de novo has proceeded in forma pauperis, costs and expert witness fees are imposed only against the amount of judgment awarded to such a party, and the arbitrator's fee is repaid to the county only if there's an amount remaining after the offset of statutory costs and expert witness fees. Now, Section 1141.26 states that an arbitrator's award can exceed $15,000. But no party electing a trial de novo after such award shall be subject to the provisions of Section 1141.21. Okay, I think that's all I have in that section, Alex.
Well, that's taken us all the way through the judgment. Maybe to recap, we can sort of set up a situation here with learned counsel on both sides to consider the progress of these matters through the court system. The plaintiff has filed a complaint, the defendant has answered, law in motion is concluded, the discovery is fairly well in that way, and all of a sudden you open your mail and you see notice that the court says you're invited to attend a status conference to determine whether or not the court should determine the case to be subject to arbitration. Why don't you take it from there? Who's first?
I'll start, since I am the one who filed the complaint.
We're going to assume, Norm, that it's the typical case that you and I very often have that's in the San Francisco Superior Court, and we're going to take it from there?
I think it's the kind of case we'll see most often in arbitration. The average personal injury case. You jumped the gun a little bit, Alex. I'd like to talk about how do I decide whether to put that case in Superior Court or Immunity Court. You've got a case of a moderate personal injury. You've got $15,000 jurisdiction in the municipal court. Why not go there? I think what we're going to find is, and I know that's the way that we treat these matters, is we don't know where that case is going to end up in terms of the amount of damages involved. We're going to be filing those cases still in Superior Court. Now, when I filed a case in Superior Court and the answers come in from Bill, we're going to engage in discovery immediately. Perhaps we file the case 6 or 8 months down the line, and we find out a month or two after we file that the plaintiff is pretty much over any of the problems medically and so forth. And we've come to the conclusion that, by golly, it's a case worth less than $15,000. So we have some thoughts and we have some decisions to make. One, shall I elect arbitration? I can do that, of course, under the statute. Should I wait until the court's going to order me to arbitration? And those are the factors that go into the plaintiff's mind, some of the things that we think about, we decide. Now, we try to move a case. We don't want the plaintiff to have to wait any longer than possible to obtain a recovery. We will exhaust every opportunity in the smaller case to settle that case with the insurance carrier. And if we're unable to do so, then we're going to elect arbitration. And we realize in many courts that if we elect arbitration, we sure better get our discovery done. So we're going to, after your answer comes in, Bill, we're going to ask for the deposition of your client, and we're going to send out interrogatories, file a memo to set immediately, or elect arbitration, as I've indicated. So that would be the first step that I would take in that regard.
For the purposes of our illustration, Norm, let's assume that you filed your lawsuit and you're doing your discovery and you filed your memo to set, or at issue memo, on January 1st of a given year. And let's also assume that you've decided in this instance that we'll proceed with the case as if it were going to mandatory arbitration rather than elective or stipulated arbitration.
Might make an assumption, too, that the backlog is not all that big. So you're not just getting a place in line, you're really thinking of going forward to trial.
Well, the courts are doing, I think, extremely well in reducing those backlogs. So I think that we may find ourselves within a reasonably short period of time, perhaps that's a year, perhaps that's 2 years, but in almost all counties, with 1 or 2 exceptions, ready to have that conference 9 months after the at-issue memorandum.
Well, yes, I agree. There are going to be times when you're going to have filed or elected for arbitration where you'll find your case has a value greater than the $15,000. And what do you do then? Well, what you're going to have to do is to make a motion to get a stipulation from your counterpart, your opposing counsel, and if that fails, you're going to have to go to court and have the judge assigned to arbitration make a ruling on that. And that has happened to some offices that I'm aware of. But now that we have decided that we're going to, our mandatory arbitration features are going to be involved in the case, the court's going to call us to a hearing. So let's get into the aspect of how we're going to prepare for that hearing with the judge. What I'm going to do, in San Francisco, they're going to send me a form. And that form is going to say, ask me questions about the case, the type of case it is, the damages, and so forth. I will indicate on that form the amount of special damages and the general damages, the liability, and so forth. And I'll submit that form to the defense counsel and to the court. And Bill, you'll be doing the same thing?
Yes.
The form that you received.
I will receive an identical form under San Francisco Superior Court Rule 7. And generally, the defense in a personal injury case will probably only be filling out the first page of that form. And again, you're going to have to look at your local rules.